All right. Well, good afternoon to everybody. This is our Legal Ease show. I am missing my partner in crime, Steve Palmieri. I think he is having fun in the state of California. And for some reason, while on vacation, did not want to call in. So we'll have to give him some grief about that. But we are here. And so I'm happy to take any questions that you guys have. And let's see here, make sure I have this set up so that we can see any comments. Usually I have Stephen, he has uh, the Facebook group open and he can see comments on there. So I cannot multitask. So if I try to do much more than just talk and kind of look here, I'm using what's called StreamYard to stream this. This is about the limit of my abilities. So if you're watching this on one of the Facebook groups or on YouTube, I should see your comments. If I don't respond, then I apologize for missing those. While we wait for questions and comments to come in, I did want to share with you. Let's see, let me make sure somebody says hear you. So I'm assuming you're saying you can hear me. And if there's any problem with the audio, let me know. But I'll share something with you. And this has to do really with disputing items on your credit report. And that is that I went to order. Okay, say yes. So I appreciate that. So I went to order a sandwich, and I like club sandwiches, but I don't like cheese and mayonnaise and mustard on them. And so I go into a place. I was traveling, and this was like the halfway point. And I went in. I said, I want your club sandwich with just lettuce and tomato. And the guy taking my order said, just lettuce and tomato. And I said, yeah. He goes, hey, it's your money. Suit yourself, which I thought was sort of an odd comment. And, but I didn't think anything else about it. And then lady made the sandwich and she brought it to me and she said, now I put extra lettuce and extra tomato on there just for you. I thought, okay, well, that's really nice. So I get in my car, I'm driving, I get the sandwich, I take a bite, I'm like, I taste the lettuce and tomato and nothing else. Get to a traffic light, look at it. It literally is just lettuce and tomato. There's no turkey, there's no ham, there's no bacon. And I thought, that's probably a pretty good lesson for, we need to be specific. And I said lettuce and tomato only. Now, in my mind, that meant other than the meat. Okay. But technically, what I said, they made the sandwich just like I asked for. So I had like the world's most expensive, I guess it would be LT, right? Because there was no bacon there. So when you're doing disputes, for example, on credit reports or dealing with debt collectors, whoever, just remember that silly little story of my very expensive lettuce and tomato sandwich. Be specific. Don't assume. Make it just crystal clear to the credit bureaus or whoever you're talking to. Here's exactly what I want for you to do for me. And so that was a lesson for me, and I will try to remember that as well. So let's see here. We've got Donald. Good evening. So good evening to you, Donald. And let's see. Jacoby Walker says, what would be the first letter to send the bureaus for inaccurate information? So, people have different approaches on this, Jacoby. What I do is when I'm helping clients to dispute inaccurate information, I put everything. Okay. I mean, every account, every error on every account. I put the incorrect personal information, or sometimes I just say, this is my name, or these are my names. This is my address. These are my correct phone numbers. Get rid of everything else. I put everything in that first letter. Now, there is a different approach of maybe your first letter is kind of a little bit vanilla, kind of a soft letter, and then you see what happens, and then you start sort of ratcheting up the pressure. And I get that, and that can certainly work. From my standpoint, though, as a lawyer that sues the credit bureaus, I want to put out all the errors on, that I can find. and they either get fixed or the accounts get deleted, or the third choice is I'm suing somebody. Okay. So I typically don't do multiple rounds of disputes. Now there's always exceptions, but generally I'm just doing one letter. I list everything that's wrong about every single account. And then I see, did everything get fixed? So I look at the results of investigation, and then we have our clients pull from annualcreditreport.com their new credit report to see after the results of investigation or after we should have received results of investigation. And we check it. Did everything get fixed? Did it not get fixed? Did it get deleted? And whatever did not get fixed or deleted, then we sue on that. So that's my approach with it. Again, there are, kind of a little bit generic letter, and then a little bit stronger letter, then very detailed letter. And that can have its advantages as well. Just for my purposes, I'm not in the credit repair business, so I don't, people don't pay me money to do disputes. I'm doing disputes and stuff's getting fixed. I don't make any money, but I have happy clients, or we're suing somebody. So that's my approach, and I'm sure that influences the way that I do that. See, Roger says, sounds great. Okay, good. Yeah. I I did a webinar earlier today, and it's supposed to be at 1:00 Central. And for some reason, I did it at 12 Central. And I was like, oh, that's kind of weird. Nobody's here. Usually, we have a pretty good number show up for our webinars. And then after I got done, I realized I did it at the wrong time. So it would be like doing this and like I'm muted or something. That would be unfortunate. So thank you for telling me. And let's see, Tashika Holmes. Hello, old friend. Yeah, long time. So good to see you, Tashika. And thanks for being here. Reach out to me by email. Let me know what's going on. Let's see. Jacoby says, should it be, I see, inaccurate late payment January 21. Please delete ASAP, or we tell them to validate or verify as your first letter. So what I would do is any errors that I have that I can identify, I basically just use this language. Please fix this or delete the whole account. So I don't say validate or verify. It's just, I want you to fix it or I want you to delete it. Those are your two choices. And, so we're very specific in our letters. So for example, we would not say the payment history is inaccurate and just leave it at that. We'd say the payment history is inaccurate. For example, in January 2021, you show me being 60 days late when really I was 30 days late, or you show that I didn't make a payment. Actually, I made a payment on January 15, 2021. So again, try to be as specific as possible, because that puts a greater burden on them to investigate. And if they don't fix it and they don't delete it and you end up suing, it's much more persuasive to the judge when you can say, look, I spelled it out in detail and they still didn't fix it. And then the judge looks to the credit bureau lawyers or the furnisher lawyers, say, why didn't you fix it? And then, they kind of stumble around. So that's my approach with it. Like I said, I don't really get into validate this, verify this. I just say, here are the errors, fix it, fix each error, or delete the entire account. Now, I only dispute accounts that I'm willing to and comfortable with all the account being deleted. Okay. So, if you've got a mortgage with a 30-day late 6 years ago, and you've had that mortgage for 15 years, I personally wouldn't dispute it, because there's a chance, the way that I dispute, that the whole thing would be deleted. So I just try to delete or attack things that I'm comfortable being deleted, so that, again, I like to make things very simple. So somebody mentioned to me, when I wear a tie, which is obviously only when I have to, all my ties are red, and, my shirts are like white or blue, and all my suits are dark suits, because I like to make things simple. So again, with these dispute letters, I like to make it simple. Fix it, delete it, or then I'm suing. So that's the approach that I take. See, Tony V. Hey, you're very welcome, Tony, and good to see you here. And let's see, Marcus says, what if a collection account got deleted from Experian and Equifax because it's unverifiable, but TransUnion keeps coming back verified? So that does happen. So my view is you kind of have to look at these independently. If first of all, it's great that it got deleted off Experian and Equifax, but if TransUnion is verifying it and if there's nothing inaccurate about it, then there's not much to do. So I would definitely look to find any inaccuracy. The date open, that's going to be the date that the collection agency received the account. Is that correct? Is the amount? Is the original creditor? Make sure you're looking on for TransUnion, your actual TransUnion report. So go through annualcreditreport.com because it's going to give you the greatest amount of data. Now, unfortunately, TransUnion typically doesn't give us like a monthly thing on collection accounts. Sometimes you'll see that with Experian, but still look at every piece of data you can. And you might send a validation letter to the debt collector directly, get documents back from them. Sometimes though the numbers on those documents don't match the dollar amounts on our credit report. So you're looking for anything that shows this is suspicious, this is not trustworthy, this is inaccurate, incomplete. But just simply because it was deleted off Equifax and Experian, to me, is not enough to, for example, to sue that it's on TransUnion. Let's see. Tashika says, how do I dispute medical bill collections when I had to get insurance updated? So my question for you, Tashika, would be, did they submit it on the wrong insurance? Or, was there some error that was the fault of the medical provider, or was it our fault, or, what happened there? Because if, for example, they filed it on the wrong insurance and you say, hey guys, you filed it on the wrong insurance, here's the correct insurance, and then they refuse to resubmit it, or maybe they waited so long that now Blue Cross denies it, well then, I think that gives you a basis to challenge the underlying debt. Okay. So maybe give me a little bit more details on what happened, kind of a little timeline. I had this insurance, then I went to this treatment, and then I needed this new insurance, or whatever happened, and I'll be glad to give you my thoughts on that. Let's see, Business Ventures. This is Donna. I've been disputing with Portfolio Recovery. I did send them 3 rounds of letters, but still it's not off my report. What do I do next? I got everything else off except for them. So, Donna, my first question is, have you been sending those directly to Portfolio or to the credit bureaus? And then what's the basis for challenging? So again, this is just my world of litigation. So, I've sued Portfolio Recovery more times than I could possibly tell you. And so that colors everything that I do. Okay. So I look for, there's got to be something wrong, and then we dispute it, or we find an error and then we point that out, and then they don't fix it, and then we sue. Okay. Or, if we're going under the FDCPA, Fair Debt Collection Practices Act, it might be that Portfolio is just doing something wrong with their letter. Like say it's an account that's been delinquent for 8 years. I sued Portfolio Recovery on this probably 15 years ago. They said on an account that was way outside the time limit to credit report, they said, please be advised, we may credit report. Well, I sued them for that. And they go, well, we didn't say we would credit report. We said we may. I'm like, yeah, that means there's a possibility you will credit report. And it's 100% certainty you cannot credit report because it's too old. So again, I'm looking for something when I sue that this is an error. Okay. Now, I will say with Portfolio, unless they've changed their policy recently, if you do settle with them, they will take it off your report in about 30 days. Now, you may not want to settle with them. You may, have questions about whether they own it or not. But I would just look for errors or look for things that you can ask them for. So, for example, I like to ask for, if it's a credit card, I want the last statement with the 0 balance. And then I want the most current statement from the original creditor and everything in between. Because if you just give me, say, the last 3 months and it has a starting balance of $1,200 on, the newest statement, well, how do I know that $1,200 is correct? So that's why I want back here in the past, the last zero balance all the way to where it is now. And if you haven't asked for that, you could ask for it and say, I need this to know whether the correct charges, the correct interest rate, all this other stuff. Was that applied correctly? And then I need the contract, okay, which would be the terms and conditions for Synchrony Bank or whoever portfolio bought this from, supposedly. I want that because that'll tell me the interest rate. So I not only need the contract to know, well, what is the interest rate? What is the charge for the late fee? But then I need all those statements to see, did you apply the contract correctly? So when we ask debt collectors for something, I like to follow this pattern of, I'm requesting this because, and then you give your reason. Okay. So it's really kind of for marketing where, in marketing, you would say, here's a feature. Okay. This has, lane assist technology, which is important because if you get sleepy and you start to drift over, it'll alert you. And so just follow that pattern of, here's what I need because, and then you explain why you need it. They don't necessarily have to give it to you, but it can give you a basis to challenge based on what they do give or don't give to you. But you're just better off to ask for specific things and explain why you need them. So hopefully that's helpful. Let's see. Hey, thank you very much. And I'm sorry for this. It just shows me Facebook user. Normally this is when Stephen would say, oh, well, that's Cedric or Warren or somebody like that. So I apologize. I'm not sure who that is, but thank you for saying that. And let's see. Fern Money. Hello, I'm ready to take legal action. Bureau's response came back with inaccurate accounts still on my credit reports after 3 certified disputed detailed letters. No more nice guy. Okay. So let me just take a moment there and say, and I know, Fern, you've been on these before. Yeah, great job doing certified letters. If people do it online, I really want people to do a screen record to capture everything on the screen. Okay. So I just got through mediating a case. And one of the issues was, well, what exactly did we say in our online dispute? We didn't keep a copy of it. So it puts us at the mercy of the credit bureau and what they say that we said. So you can record the screen, get like Snagit. It's free. Or there's a trial version, Loom, Loom, or just do a Zoom with yourself and share your screen and record it. So if you're doing it online, that's what I really strongly suggest. But my preference by far is do it by certified mail. And so Fern says here, I did it certified, disputed detailed letters, and they're not fixing it. So yeah, that's the time you really need to talk to a lawyer. I'm not sure where you live. You're welcome to reach out to me, alabamaconsumer.com, and just share with me where you live and the details. And then, we can either look at doing something in Alabama if we feel like there's a suit, or we can work with a lawyer in your state, or I can just send you to some lawyers in your state that can help you. And so, yeah, it sounds like you've done everything. If you've done detailed letters explaining the inaccuracies and they're not fixing it, then yeah, there's no reason to do a 4th round. Okay. I think 3 chances is plenty. Let's see. Kim says, portfolio suing me for Synchrony Walmart. They had the last 4 of the account number wrong, possibly a typo, but they used it on the letter from Synchrony, letting me know they were selling my account. I never received the letter before the bill of particulars. Obvious to me, they try to cover it up. Okay. So let me make sure I understand what you're talking about, Kim. This is often called a goodbye letter. Okay. So Synchrony Bank will say, hey, we just wanted you to know your account. We sold it to Midland, to Portfolio on this day. And then usually, or I shouldn't say usually, sometimes you get a letter from the debt buyer, like Portfolio Midland, saying, hey, we just bought your debt. But sometimes you get those letters, a year after the fact, and they'll be included with all the paperwork. And sometimes what we've noticed is, like, let's say I lived at 123 Main Street when I had that Synchrony, I think yours was a Walmart. Yeah, Synchrony Walmart account. And then I moved. And then after I moved, it was sold to Portfolio. At least that's what Portfolio claims. Well, the goodbye letter from Synchrony will have my new address, but it will be dated back when I lived at my previous. I hope that makes sense. It look it they just created the document after the fact. Okay, and with these account number wrong, I would just make sure that's actually the account number from Synchrony, not supposedly the account number from Portfolio. But anything like that you can point out, that could be very helpful. And if you've been sued by Portfolio, and it sounds like you have been, or you're in the process of it, I would definitely get with a lawyer in your state who does this type of work to say, hey, look at this. What are my options? Do I have a realistic chance of winning this case? Can we settle with Portfolio without paying them any money? Do I need to pay them money? Should I do this with a lawyer, without a lawyer? But that definitely could be helpful if you can start to show some things that make it look suspicious, because Portfolio is going to come in and go, Your Honor, we bought this. Everything we have is the gospel truth. And then when you can start pointing out all these errors, it makes the judge go, well, maybe this is not so accurate what you're claiming. And so I think that would be very helpful, and sounds like you've already started doing that. Let's see here. Miles says, do you work on any NCTUE issues? If so, can you expound on this? So I think the short answer is no. I do want to ask Miles, though, is that for credit unions, or maybe explain to me what NCTUE is? I'm not recognizing it, but maybe it's been a long day. And so just give me a little bit more information on that, and I'll be glad to tell you either I have no idea what that is, or if I have an idea, I'll be glad to talk to you about that. Let's see. Kim says, is there any defense to that? That's the deal with the Portfolio and the Synchrony. Yeah, I think there can be, because keep this in mind. So you had a debt with Synchrony Walmart. I presume you owed money to them that you did not pay. Okay. If Synchrony Walmart sued you, I'd say it's Synchrony Bank. It's like a Walmart card. If Synchrony Bank sued you, well, you have much less of a defense than if Portfolio sues you. Well, why is that? Because Portfolio, you never did business with them. So they have to prove that they bought this debt, that they own this debt, that they truly bought it from Synchrony Bank. Well, if their documents they're presenting where they're saying, hey, judge, trust us, we're telling you the truth, we really bought this debt. Well, if their documents have all sorts of errors, inconsistencies in there, that makes the judge in general be more suspicious about this and say, well, maybe you don't own this debt. So yeah, I think that can be very, very helpful. Let's see. Forest Lake says, great video. Well, thank you very much. I have a charged-off credit card and an unsecured loan with Navy Federal, and went to MRS BPO and can't pay. I've written disputes. How aggressive are they? So I'll say this. Normally, tell me what you mean by MRS BPO. Normally, I think a BPO is broker price opinion, which is really with real estate. So, but in general, with Navy Federal, I personally in Alabama, which is where I practice, I don't see them file suit. And I've had clients that they'll have like a $17,000 Navy Federal credit union, and there might be some errors on the credit report. And maybe I'm just being a little too conservative with this, but I say, look, my suggestion is we just leave them alone, okay? Because we don't want to necessarily go, poke the sleeping bear when they could come after us for 17 grand. So I haven't seen them be aggressive, and I'm not even sure I've ever seen them sell the debt. So from that standpoint, they seem much less aggressive than a normal credit union. I mean, normal credit unions in Alabama, they're great if you never have any problem. But if you ever get behind, I mean, they make Bank of America look like, I don't know, collection of nuns or something. I mean, they're just like, they make Bank of America look nice and Wells Fargo look nice. And how do you do that? How can you possibly make Wells Fargo or Bank of America look like the good guys? But credit unions here are super aggressive. But I haven't seen that with Navy Federal. So I'm sorry I can't give you more answer on that. But do let me know what MRS BPO is. And if this is you're talking about a real estate type loan or if that means something else. Let's see. Tashika says, I submitted on correct insurance, still have not heard back from medical treatment. And so I guess then it's gone on to collection. So what I would do is, you could dispute that with the collector and say, hey, look, I submitted this, correct insurance. I would also consider reaching out to the hospital, the doctor, the clinic, whatever it is, and say, hey guys, I gave you the correct insurance. Why do I now have this collection account? Okay. And sometimes what they'll do is they'll say, oh my goodness, I'm sorry. And they'll go reach out and recall that account from the collector, which that will make sure that either it never appears on your credit report, or if it's on your credit report, when they recall it, it should come off. Now, if it stays on there, here's how you'll know that it'll stay on there, but it won't be updated. It should be updated every month. But if you see it not be updated, then you can just do a dispute through the credit bureaus. And I can help you with that, Tashika. Do a dispute through the credit bureaus and say, hey, this account, it's not accurate and they're not updating. And that usually will just get it off. So hope that will help you there. Let's see. Marcus says, send the deletion letters from Equifax and Experian to TransUnion. Yeah, so that's going back to a collection account came off 2 of our reports, but not the 3rd. And that is something. Legally, they don't have to, but sometimes it can be persuasive. So that's some good advice, Timothy. Thank you for sharing that. Let's see. Due to COVID, I will have more time. They'll try to sue me. I'm going to try to wait them out till statute of limitation. Yeah, so just make sure that you're real clear in your state on what the statute of limitations is. And not to overcomplicate this, but some agreements will say we're going to use the law of South Dakota. And you may be living in Virginia or Alabama or California. So you may want to reach out to a lawyer in your state that does consumer law and just say, hey, what do you think statute of limitations is? And I can tell you in Alabama, I think it's clear, but some of the judges think that it's not so clear on a credit card. What is that statute of limitations? Is it 3 years? Is it 6 years? And so, you want to kind of have a good idea for how long you sort of have to hold your breath and how close you are. And, but I think, if you go that route, then, you just, in my view, you don't want to do anything to sort of get their attention. So certainly not disputing if you don't have to dispute. All right. So Kim says on my Equifax portfolio shown as closed. Yeah. With that, it gets a little odd on how that should be reported. So we're talking about, is this an open account? Is it a closed account? Generally, we think of open account as an account that is active that you can use. So if it's a credit card, you can go spend it. If it's a real estate transaction, you're still in the process of paying. So you can always ask what that means. We can get a little bit more detailed using what's called Metro 2 guides, which is the CDIA resource guide. Metro 2 is just what we call it. That's the data format. We can look up and see, okay, well, what is an open account? What's a closed account? How does that differ if it's a collection account? And sometimes that can be helpful, but you can also just, ask them like, hey, why is this showing as a closed account? Please explain this to me. And so sometimes that will do the trick. Thank you very much. It is okay. Well, very good. Very good. So Tashika, yeah, let me give you that. I'll give you this one. And this will come to my work address. And so it's johngwatts@gmail.com. So hopefully that will be posting there. And let's see, Timothy says, can a charged off account still say open an account status? That's an interesting question, Timothy. So normally a charge-off account, as I view it, would be closed. In other words, you can't, if my Discover card is charged off, I can't go stick it in the gas pump, right? It's closed. It's not working. So I think that's a little odd that it would say open. I'm trying to think if there's any scenario where that would be appropriate. I'm not thinking of one. So yeah, that would be something that I like to ask questions in, for example, my dispute letters to the bureau. Say, why would you say my status is charge off, but you also say that it's an open account, under the account status? It seems like those are contradictory. Please explain this to me. And understand this: the credit bureaus are never going to give you a personalized response. At least in 20 years of doing disputes and suing them, I've never seen a personalized response. But think about, you're writing it for the person that's investigating. Let's assume they're trying to do a good job. Well, you want to help them as much as possible. And if they're not doing a good job and they're not going to fix this, and you do end up suing, you want a judge to read and go, yeah, that's a pretty good question. So Equifax, what did you tell him in response? Show me your letter. Like, well, we just have this automated results investigation. Like, yeah. But where did you respond to his question? That's a good question. Where did you respond to it? Well, Judge, we don't respond to questions. It puts them in a bad spot. Let's see here. What's the best way to get rid of IC systems? So that's a good question. It depends. So I'll say this: the best way I know of to get rid of them is you sue them when they break the law. Now, I say that having, I've had a jury trial and verdict against IC systems, so maybe I'm a little biased towards that approach. But really, all these, what we'll call traditional debt collectors. So IC systems never claims, to my knowledge, to own a debt. They're literally a third-party collection agency. When you sue them, they tend to be at least somewhat smart, and they get rid of the account very quickly. Okay. So I would be curious, Broby, what type of debt is this? Is this like a medical debt? Is it, DirecTV, Sprint, Verizon, cell phone, satellite, DSL, just like what type of debt is this? And that can influence sort of my answer. If it's, hey, you didn't turn in your Charter cable box 5 years ago when you moved, and you did, I just sue them. Okay, it's false credit reporting. They're collecting a debt that's not owed, and so that's certainly a approach that I think can be very useful. And then I would follow that up, or maybe do it at the same time, where you go after Charter under arbitration. And I did a whole webinar. If you're interested, just reach out to me personally, and I'll send you the link to that. It's probably a 60, 75-minute webinar on dealing with cable companies and cell phone companies when they have a bogus charge and they send it off to a collector. The basic gist is we sue the collector, sort of nail them down. They have to pay money. They stop collecting. They get off our credit report. And we go after whoever was the original source of the debt: Charter, Spectrum, AT&T, DirecTV, whoever it is. And that can be an effective strategy so that you don't end up just getting rid of IC systems. Like, you could send them a dispute letter and they probably would get rid of the account. It's just going to go to the next collector, and you got to do that. So it's sort of like whack-a-mole, if you've ever been to, Chuck E. Cheese's and played that game. So that's why I like to, if I find a violation, sue the collector and go after the original creditor, typically with arbitration. Let's see. Forest Lake says, I have a charged off Walmart being collected by LVM via road disputes, only $841. Can I just keep them at bay? Will they sue for that small amount? Thank you. So you're very welcome. I'll tell you this. If you had asked me 5 years ago, I would say I've never seen LVMV sue for that small. Starting, I don't know, 3-4 years ago, the amount started going down, we have seen LVNV sue in Alabama for $400. I don't know what state you're in. I don't know, um, what the custom is in your state. If you're in Alabama, yes, you could definitely be sued for $841. There may be other states where they don't sue for less than $1,000 or $2,000, but um, here's what I would do. If you're concerned about it, um, you can look for errors on the credit report, dispute through the credit bureaus. You can reach out directly to LVNV. And I did, again, a webinar. We do a weekly webinar. Um, this was actually before I started doing it on a weekly basis. I had sort of separate webinars, but I did one on, it was probably hour and a half, 2 hours, on really a super deep dive into dispute letters sent directly to collectors. So what's a dispute letter? What's most people call it a validation letter. I like to call it a request for information, because that's what it is. You're requesting information. Or a refuse to pay, which is cease communications. And when can we combine those? When should we not combine them? What's the effect? What's the strategy? If you're interested, again, just reach out to me and say, hey, send me the link to the replay for that. I think what I called it was FDCPA Dispute Letter Masterclass, and be glad to send that to you. And that may give you some ideas on what to do. And then check with a lawyer in your state about, can you be sued as a practical matter for something that small? Hopefully the answer is no. But again, if you're in Alabama, the answer is yes. Okay, Kim says, trying to defend myself, it's a few suspicious things. And then thank you for your advice. You're very welcome. So nothing wrong with defending yourself. I would still talk to a lawyer. I know for me in Alabama, if somebody says, hey, I'm defending myself, can you give me some advice? I'm always happy to do that. And two reasons. One, I think I'm a nice guy. I want to help people out. And so, I'll even go through a little sort of coaching session with them about, hey, I'm going to play the role of the collection lawyer at trial. I'm going to, cross-examine you here. The other is, maybe a business reason. I want that person to go win that case against Portfolio, LVNV, Midland, whoever, because then I want them to come back to me in Alabama, and we may can sue, or we may can do a dispute. And if it doesn't get fixed, then we sue the credit bureaus, we sue the debt collectors. So hopefully where you are, Kim, certainly if you're in Alabama, reach out to me, alabamaconsumer.com. But if you're in another state, talk to a consumer protection lawyer in your state. If you don't know one, reach out to me. I may know somebody in your particular state, and just say, hey, am I on the right track? Do you have any advice for me? And hopefully they would do the same thing and help you out. Let's see. Oh, okay. I got you. MRS BPO is a collection company. Yeah, that's right. I have seen them only maybe one time. And, when I first was reading, I was like, who is Mrs. BPO, broker price opinion? But yeah, now I'm familiar with that. So, Force Lake, I would just go back to, sort of reach out to that collector again, whether you do a dispute letter with request for information, or a dispute letter saying, hey, I refuse to pay. Different strategies, but I would look at that and see if that would help. Let's see. Mark says, if I'm duly paid for online sell to scammy buyer, and auction site arbitrarily demands refund, misciting terms of service, can the site or their collectors unilaterally report as debt to CRAs given NCAP rules? So I'm not sure what NCAP is. So I'm assuming what happened is, whether this is eBay or real estate or whatever, you sold something and now they're, reporting it as fraudulent or whatever. And the auction place is saying you have to pay this, have to give them a refund. So as far as whether that could be reported to the CRAs, normally we think of debts being reported as things we voluntarily undertook. Okay. But it's not limited to that. So if, if I'm in a wreck and it's my fault and the insurance company sues me or they turn it over to collection, even though I didn't sort of voluntarily create that debt, it still is out there. Now, that may or may not be subject to the FDCPA, the Fair Debt Collection Practices Act, because it was not voluntary. But they can report that and they can collect on it. So the thing with the credit bureaus, keep in mind, is we can certainly challenge things, and when we can show errors or incomplete information, then the credit bureaus have an obligation to fix that. But when it's stuff that's sort of outside that they wouldn't know, like, do they know this is outside the terms of service? Do they know whether or not you did the sale correctly? We wouldn't necessarily look at suing the bureaus for that, but whoever's reporting it, we could look at suing. So if the collectors are reporting this to the bureaus and it's inaccurate, it's not correct, you can dispute that. And it may be that the bureaus have no liability, but as long as they notify the furnisher here, the collector, that you've disputed this and your reasons for dispute, then those furnishers, those collectors, have an obligation to investigate properly. And if they don't, you can sue them under the Fair Credit Reporting Act. So that's the approach I would take. Sort of build your evidence on, here's exactly what happened. Here's the terms of service. Here's why I'm in the right, they're in the wrong. Lay all that out. I kind of harp on this. I don't care if the dispute letter to the bureaus is 27 pages long. Make it as long as it needs to be. Okay. We've had dispute letters for one account that went probably 12 pages. I'm not talking about attachments. That's extra. I'm talking about just detail after detail after detail of what happened. And so you don't make it longer than it needs to be, but make it as long as it needs to be. Put all the attachments you want, all the enclosures. And then, if it doesn't get fixed, then you may have a good claim against that collector. So that's the way that I would approach it. Let's see here. Have you ever used or heard of a firm mailing book to track mailings? I'm not familiar with that. The only thing, if you're talking about like keeping track of certified mailing, I use a company called Certified Mail Labels. I think it's certifiedmaillabels.com. They're out of Celebration, Florida, which is a little suburb of Orlando. It's kind of the town Disney built, so to speak. It's a really cool little town. They're a great company. Been using them a long time. I don't get anything for recommending. They don't even know I'm recommending, but I love their service. You upload the documents, they send it out by certified, and then you've got a list of everything you've sent. You can go click on it, see your actual document, see the history of the document, all the post offices it went to. And then if you pay for it, see the signature. So if that's what you're talking about, that's what I use. If you mean something else, just let me know, and I'll be glad to give you my thoughts on it. Let's see. Tashika says, sent correct insurance certified mail into treatment clinic and collection. Yeah, so that's great. I would see what the response is, and just let me know what you get back on that. And let's see, Willie Fry, John, can I get a copy of your dispute letter? Yeah, I give away everything we have. So if you're talking about dispute letter to a collector, I certainly can give you that, and I can give you that masterclass webinar on using dispute letters, and because I want you to understand the theory of what are we doing, not just, hey, here's a form, use it. And then if you're talking about to the credit bureaus, I did a 6-part webinar series on how to do proper credit report dispute letters, so that either it gets fixed, it gets deleted, or you can sue. And again, we have form letters in there, spreadsheets, all sorts of tools. If you're interested, just reach out to me through alabamaconsumer.com. Let me know what you want. I'll send all that to you, all the templates, everything that we use. And here's my email if you want that. And let me find where we are in the comments. Tim says, thank you for your answer. You're very welcome. And thank you for the question. And Broby says it's a medical. Okay, so that's the debt you're dealing with. Let's see. Can a lawyer bring a lawsuit under the original creditor's name? So, like One Main Financial, instead of the debt collector's name, Wilmington Trust NA. So, I'm going to give you a couple answers here. If we're talking about real estate and a foreclosure lawsuit, then that's going to depend. Well, all of this will depend on your particular state law. Okay. I can tell you in Alabama, for example, for foreclosures, those are done non-judicially. So there's no lawsuit. After they foreclose, then they sue you for what's called ejectment, same thing as eviction. And that would be in the name of whoever owns that piece of property now. If it's a collection lawsuit, at least in Alabama, it has to be brought under the name of whoever owns the debt. Okay. So in your example, if One Main Financial owns the debt, that's who the name should be. If Wilmington Trust NA has bought the debt, that's who it should be in. Where we sometimes see these guys get into trouble is they'll bring the name under the original creditor, but really it's been sold to a debt buyer. And they're doing this because it certainly is more intimidating to get a lawsuit from the original creditor. You know, imagine it's Capital One. I get sued by Capital One. And I'm like, yeah, I had a Capital One card. I didn't pay it off. That's a whole lot different feeling than LVNV, who says, well, 5 entities have bought and sold your account, and now we hold it, and now we're suing you. I'm like, I can beat LVNV, okay? A lot harder to beat Capital One. So when we see them do stuff like that, then that's when there needs to be a lawsuit brought against, the lawyer, against the debt collector, against the original creditor, because they're all sort of involved in this, really lying to the court, okay, and being deceptive. So just give me some more information if that didn't answer your question. Okay, Forest Lake and state of Georgia. Reach out to me. I have a very good friend, lawyer that I work with in Georgia. Matter of fact, right before this webinar, I was like, okay, I got to get off the phone because I got to do this webinar. He and I work on a lot of cases together. He gets me involved in cases in Georgia. I get him involved in cases in Alabama. So reach out to me and I'd be glad to connect you. Let's see. Tony says, Pass, I believe you mentioned something like there's a tricks and things to do to remove a charge off. How to delete a charge off. Okay. So really, if I said that there are some tricks to do, I don't remember saying that. Normally what I say is, let me say, there are some things, you can put sort of nonsensical language, and some people, will sell you letters doing that. And, or you put on pink paper with green ink. And I don't think that helps any. Okay. Sometimes it works, it's sort of like saying, well, when you put the letter in the envelope, if you'll stand on one leg and have this arm raised and these fingers crossed as you stick it in, and it might get deleted and you go, oh my goodness, I found the secret. Really though, just look for the errors. There are times where I see negative accounts with no errors in them. That is definitely the exception. I might look at 20 negative accounts and there's one where I go, yeah, there's nothing there to dispute. There's almost always something to dispute. There's missing information. There's inaccurate information. There's inconsistent information. So this is where a spreadsheet really helps. So, you just imagine you have columns, and we have templates we can give you, but you've got like current balance, what happened in June, what happened in July, what happened in August. And you just copy and paste all the data from the 3 credit reports, and make sure you're using your real credit reports from annualcreditreport.com, and you'll see inconsistencies. So maybe TransUnion says I paid it off in September of last year, and Experian says it was August of last year. Well, which one was it? That's inconsistent. Okay. So somebody's wrong. It may be they're both wrong, but at least one of those 2 jokers is wrong. Okay. and there'll be missing information. So you'll be going along month, and then it's like no data, no data. Hey, I dispute it. Fill in the missing data, delete the account. Those are your options. I don't say this, but the third option is do neither one of those and get sued, and then you'll delete the account and pay my client money and pay me money. Okay. So there's almost always something you can find that is wrong. Now, if you have already found that and they fixed it, there's really nothing I know to do beyond that. Okay. Because I bring lawsuits when there's been a violation of the law. And if they're reporting it accurately and completely, nothing more that I know to do. And again, you can find stuff, where people will say, you go freeze your LexisNexis account, or you do this with SageStream, or you send this incomprehensible letter that, makes no sense. And maybe that'll get, maybe, but that's not the approach that I do. Okay, Mark said, so that's the NCAP, National Consumer Assistance Plan. So I'm not sure how that would relate to your question. I think was the auction and dealing with like a scammy buyer. So I'm just not sure how that would relate. Let's see. Eric says it's very hard to defeat original creditors like Amex in court. I'll say this. I think every time we've tried a case against an original creditor, we've won, but I don't recommend doing that because it's pretty, if they want to, it's easy for them to win, assuming you owe the debt, okay? Because they either get you on the stand or they bring a proper witness to say, you had this credit card like Amex, you used it, you didn't pay it. Here are all the statements from zero balance all the way to the end. They have all of that. They have, all their ducks in a row. And so it should be hard. Now, I've had a few times where they wouldn't settle with us and they, wanted to go to trial and we beat them. And, but that's probably more luck than some great skill on my part. And look, this is going to be very, very state dependent. How we do it in Alabama may be different than Tennessee or Texas or California or New York. But just in general, I think everybody would agree that does this type of work. It's harder to beat an original creditor than a debt buyer. Debt buyer, they've got to prove they own the debt and they struggle with that. Original creditor, now look, if we want to get really detailed, we talk about your receivables have been sold to a bankruptcy remote special vehicle. I mean, there's all this complicated stuff with securitization. Most judges, in my opinion, in my experience, aren't interested in that with original creditors, even though, frankly, they should be. They're just like, did you have an Amex card? Did you use it? Did you have a balance owed that you didn't pay? Boom, you lose. That's kind of the way that, these things typically go. So Muriel says, hello. Hey, good to see you, Muriel. Thanks for showing up here. Patrick says, how about a consumer protection lawyer in Houston, Texas? Or can I help myself? I know a few lawyers in Texas. I'm not sure they're in Houston, but if you'll reach out to me at alabamaconsumer.com, let me know sort of the details of what you're facing. And I may know somebody personally, or you can always go to NACA.com. Let me post this here. So this comment should show up. And if you click on that link, it'll take you to a place you can find consumer lawyers. And that certainly can be good. Or if you'll just reach out to me directly, I may know somebody there for you. Oh, I see. Consumer portfolio. Yeah, so just reach out to me or go to that NACA website, and I think you'll be able to get some help. And then you can decide, do you want a lawyer or want to do it yourself? Let's see. Low Country says, great information. Well, thank you very much. I have a charged off card with Wells Fargo for $4,600. What are chances of them suing me? And can I avoid service and ride them out? Thank you. So in Alabama, we don't see a whole lot of credit card lawsuits from Wells Fargo, but the ones that we do see would be in this range or more. So I think that's definitely big enough to be sued over. Now, as far as avoiding service, I'll just tell you this. That's not a strategy that I like. Um, I know some people do it in terms of sort of writing them out. Here's the only way that works. If they can't get you served and the judge starts sort of beating up on them saying, you got to get him served or her served, or I'm going to dismiss the case. And if the statute of limitations has expired, then they wouldn't be able to sue you. But statute of limitations is from the date they filed the suit. It may take them 5 days, 5 weeks, 5 months. I've seen them take 5 years to serve you. All that matters is, did they file the case before the statute of limitation expired? Now, if they can't get you served and the case gets dismissed and the statute's run, yeah, then, that's been successful. But I just find most people get kind of burned trying to avoid service. First of all, I don't think it's the right thing to do. That's my opinion. But second of all, you may say, well, I didn't answer the door, and the process server will lie and say that they did serve you. And you're thinking, hey, I'm golden here. They didn't serve me. But the court's told that you were served. The clock's ticking. Then there's a default judgment. Then you're trying to undo this default judgment. So I don't like that. But then again, my approach is we file answers before we're served. A lot of times we know we've been sued before we've been served, and we'll go ahead and file an answer. And, we do that in part just to send a message to the other side. Say, look, we're not running from you. We're running towards you. And sometimes I use the example of David and Goliath. If you read the story, David's got the slingshot, Goliath's got, spear and shield and sword. If it was me, I'm staying as far away from him as I can. I'm just like flinging rocks at him. David runs toward him, I presume, to get within range, but you got to figure Goliath is like, this is kind of weird. Why did, he's little compared to me. Why is he running towards me? And I wonder, like, when that sinking feeling hit him before the stone, like, crushed his, skull. And so anyway, that's what we do. We want to get to trial. We want to engage with these people. So that's also my perspective about, I'm not a fan of avoiding service there. Let's see. Also have charged off Amex for about $2,000. Kind of do the same thing. Will be any relief in any of these $3.5 trillion budget bills for normal people? Probably not on this, to be brutally honest with you. I've seen Amex sue for maybe like $5,000. I'm not sure I've ever seen them sue just for $2,000. Again, that can be very state specific. So I would get with the lawyer in your state and see, sort of what the custom is. Will you likely be sued for this amount of money? And okay, Willie says unsecured loan for under $6,000 in Ohio. Yeah, I would get with an Ohio consumer protection lawyer and just find out, what they say about that. See, if I'm sued by an original creditor, can I ask the lawyer for the contract and statements from zero, asking them to prove the claim? Is this a good strategy in court if representing yourself? So I'll give you my thought on this. I usually don't ask for that stuff before trial. Now, that's probably the minority view among lawyers. The majority view is you want to ask for this, you want to kind of push them, be aggressive with them. I tend to not do that. I just say, hey, let's show up to trial. Let's see what they have. Now, the downside is you're walking in and you don't know what they're going to give you. Okay, so I've walked into trials and they go, here's 200 pages of documents. Like, I didn't know because I didn't ask for it. So I'm trusting, my ability in court that I can react quickly to that and I can, flip through that information very quickly. Maybe that's justified. Maybe that's just my ego, but we've had a lot of success doing that. But the concept of the zero to the current, not every judge is going to accept that. I think it's right. Okay. I think to just like start in the middle of this and go, well, here's a statement that says $2,314. Like, well, how do we know that that's accurate? I think it's a valid strategy. Again, not every judge agrees with that, but I think they should. And as far as whether you ask for that ahead of time, that's a judgment call for you. I would definitely recommend wherever you are, talk to a lawyer. Okay. I mean, I have people that will call us, that will reach out through our website and say, I know I can't afford you. I know, there's no point hiring a lawyer. And I'm like, well, wait a minute, let's talk. Okay. And I'll just tell you this, we do not compete on price. Okay. We are, to my knowledge, nobody charges more than we do for these types of cases, but people are often surprised at uh, how it makes good sense. And also there are times where I look at their credit report and I go, man, we're going to have, a number of lawsuits here. Here's my fee. You may not can afford it now, but, just pay me when you get money out of these lawsuits. And, they're like, hey, that sounds great. So I would talk to a lawyer, that does this type of work in your state and just see, should you represent yourself? Do they have resources for you? I mean, we have resources on YouTube, on our website about how to represent yourself, how to, 7 mistakes to avoid when testifying, all this type of stuff. And so in your state, there may be somebody that does the same thing. And so they can help guide you, or they may say, hey, look, you really need me. Here's my fee. And that may be affordable for you. So I would check that out. Let's see. Fabian, hope I'm saying your name right there. Fabian says, are collection agencies required to generate purchase agreements or contracts upon request? So let's kind of distinguish what we're talking about here. A traditional collection agency does not claim to own the debt. They're just like, hey, it got sent to us, we're collecting. They do not have to give you their contract between them and Capital One or Discover Card. And you can ask for it, but they don't have to give it to you. If we're talking about a debt buyer, so Midland, Portfolio, LVNV, Jefferson Capital, Calvary, Crown Asset, Second Round, these are the more prominent ones. They claim to have bought the debt. Well, they would only do that through a purchase agreement. Okay. So that's how they would get those 1,000 accounts or 10,000 accounts. Now, they will never give that to you. Okay. We ask for it. Okay. So in my request for information FDCPA letter, we say, hey, I want the purchase agreement to see if you really own this debt. If you claim to own it, I want to see the purchase agreement. Now, they'll never give it to you, but we've asked for it because we're sort of laying the foundation for if they sue us and then they don't produce that at trial. We can say, well, I asked for it before they sued me, and here we are at trial. They still haven't produced it. Okay. So that's the approach that I take with it. So, our collection agency is required to generate purchase agreements or contracts upon request. I would say it depends, and it's more of something that you use to enhance a case you have or to enhance your defense. Okay. So you may ask for it and they don't give it to you, but sometimes the asking for it proves very valuable. Let's see. Have a question. If creditor is reporting a charge off each month, is that legal? Yeah, unfortunately it is, assuming they're doing it accurately. As long as they're reporting on you, the current status in August of 2021 is this is a charge-off account. Now, July, assuming this is accurate, yeah, charge-off. June, charge-off, sort of, working your way backwards there. So it's frustrating because you'll see just, charge-off, charge-off, charge-off. Generally, from a scoring standpoint, it's just the fact that it's a charge-off. It's not like because they've been reporting it for 12 months that typically is more damaging to you, at least as I understand it. But it is legal. Again, just look for those inaccuracies, those incomplete information data fields. So, it's got the month of June and there's no data in it. But July, it has the balance and the schedule payment, the amount paid, the rating, your 30 days, 60 days charge off. And in the month, before that, it has it. But the month in the middle, it's just empty. Like there's no data. That's perfect. Dispute it. There's no data there. Look for inconsistencies between the 3 credit reports. And a lot of times you'll find those inconsistencies. They're just very, very sloppy. And my view is they didn't ask me if I wanted a credit report. They maintain a credit report on me. And so I have no choice in it. But what I do have power is to say, if you're not doing it 100% accurate, 100% complete, I have the right to dispute. And if you don't fix it or delete it, I have the right to sue you. So that's the approach that I take. Let's see. Evelyn says, could this work with tax liens? So, Evelyn, I'm sorry, I'm a little behind here on if you asked a previous one, sort of elaborate on that as far as tax liens. So typically tax liens don't show up on our credit reports. A tax lien is the IRS or your state Department of Revenue, whatever it's called. They say you have unpaid taxes. Now, I'll just tell you this, with federal tax liens, and most people don't know this, the tax lien is there automatically. So they sometimes file a notice of filing federal tax lien. That's just to give the world notice and, to sort of secure their place in line on your property. But the tax lien just automatically appears. States can be the same or different. But tell me what you mean by could this work with tax liens, and I'll be glad to give you my thoughts on that. All right. So yeah, this is the link for NACA, National Association of Consumer Advocates. Let's see, Low Country says, do you do foreclosures also? Will new CFPB rules going into effect 8/31/21 stop foreclosures until January 22? Heard it will. Just trying to survive. So I do foreclosures or foreclosure defense in Alabama. I have got to look at those new rules. What's happened is since COVID hit, and whether people agree, disagree, this is a reality. The government, starting with Trump, and certainly Biden has continued it, has, put these moratoriums on federally backed foreclosures, which is like VA, FHA, Fannie Mae, Freddie Mac, Ginnie Mae, USDA, about 2/3 of all mortgages. And so we really haven't seen any foreclosure activity with those guys, and very little with the non-federally backed loans. And so I haven't been that involved with, looking at those rules because they just keep getting extended. But I do know some new rules have come into play, and I just haven't studied them enough to kind of speak to that. But I will look at those and take a look. All right. See, following up on my question regarding original creditor in court, what's their incentive to settle so hard to defeat them? Well, first of all, they can lose. Second of all, it can be costly for them to prove their case. So I'll just talk about Alabama. So if you represent yourself, you have to show up to trial or you lose, default judgment. But let's say I represent you in Alabama. Well, I'm not going to want you to show up unless there's some good reason for it. Unless they subpoena you, which they very rarely do, then you're not going to be there. So they can't prove their case through you. So they've got to bring a witness. Well, do they have to fly somebody from, wherever Citibank's headquarters is, or Capital One? Here we are. This is what, August the 12th. The Delta variant is, raging out of control, and parts of Alabama and Florida and all sorts of places. And so, their person that flies around the country to testify may be like, I'm not getting on a plane, so those are some incentives. And then just the fact that, okay, they get a judgment. Now they got to collect it. Does your state have wage garnishment, bank garnishment, liens on property, sheriff sales of personal or real estate property? So they may be very happy to work out a deal with you and not have to go through all this effort. So that's typically why they'll settle with you. Let's see. Rig says, I have a court date February 1st, 2022. Happy I found you. Well, I'm glad also. Been binge watching all your videos. Well, the only thing I'll say is, binge watch my videos if you want to go to sleep. I've been told my voice, it's calm and it puts people to sleep. So maybe I should make like meditation CDs or insomnia CDs or DVDs or something. But no, I'm glad the videos are helpful. One thing I'll tell you, with your court date in February, that's still a good bit of time. If your state is open and your particular court is open, I strongly recommend go to court, watch your judge. Okay. So say there are 5 judges. I don't care about the other 4 judges. I just care about your judge. Go sit in his or her courtroom. Watch what they do. Are they formal? Are they informal? Are they, rush, 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 rush? Or are they really going slow? You'll see what happens. If you can just kind of sit back, sit in one of the pews there and take you a notebook and just observe. And they might say, hey, I noticed you haven't raised your hand. Do you have a case here? Say, oh, I'm just observing. I'm just wanting to watch. They'll say, hey, we're proud to have you here. Now, COVID's kind of changed that. You might want to check. First of all, make sure they're doing it in person and not by Zoom. And if they're doing it in person, will they, get mad if you show up? Most judges won't. Okay. But some are very, very strict. I mean, I've had some trials where all the lawyers go to one room and then like the judge's assistant comes in and says, all right, I need, everybody here for Smith versus Jones. And then we walk to the courtroom, we enter the courtroom and nobody else is in there. I mean, I've had judges with, plexiglass and they've got a face shield and a mask and they have you stand like 20 feet away inside of a plexiglass. And other judges are like, courtroom is packed. There's not a mask in sight. And, you just need to know what your judge does and just observe, get a feel for it. And I think that will really help you. Let's see. Do you think it is more unethical for a bank to collect on a loan that was created from nothing? Bank reserve was lowered to zero due to COVID, fractional reserve lending bank loans. So here's the deal with all this type of stuff. I know there's a lot of, sort of intellectual thought about, the monetary supply and monetary policies and what happened when we went off the gold standard and we have, all this debt, and then we have, just the printing presses rolling. And that can be a very interesting discussion. When you're in court, judges don't care anything about that. Okay. And so I'm not fussing at you for bringing that up. I'm just saying, where I live, which is in, lawsuits, judges don't want to hear anything about that. Like if somebody starts to say that, they immediately tune you out and you're losing. Okay. Because they're like, oh, you're one of those crazy people, probably a sovereign nation person or whatever. And so in terms of what I think, if a bank loans you money, I think you should pay it back. Okay. So whether we say, hey, when we went off the gold standard or when, the Federal Reserve can crank up the presses or, lower it, and the control they have over this economy with controlling the interest rates, I have my own views about that. But if, XYZ bank loans you money, I think you should pay it back. Now, I don't think they should collect more than they're owed. And certainly if a debt collector is collecting and doing it illegally, unethically, hammer them, sue them. And even the original creditor, if they're doing false credit reporting and you properly dispute it, it doesn't get fixed, no problem suing them. But, just in general, I think, pay back your debts that you actually owe and the amount that you actually owe. Let me see here, try to catch up on these comments. Okay, so this is a follow-up. So essentially banks loan money they don't have but create legally. Yeah, look, you can go really, really deep into this. And then when you start sort of layering on top of this, cryptocurrency and blockchain technology and start thinking about, well, if we could have currency that's outside of government control, it's really, really interesting. But in terms of just sort of practical, what do I do if I get sued, or can I sue a bank? Judges don't want to hear any of that very interesting discussion. They might like it personally, but just in the courtroom, I've never seen a judge have any interest in that. See, Miro says, law limits how long you can be sued on debt. The age of your debt, Jefferson cannot sue for it. We're not reported to collection. Okay, so there's a couple of limitations period. The time limit to sue is statute of limitations. Okay, so nothing to do with credit reporting. Think of all these time limits as independent. Statute of limitations is time period to sue. The time period to credit report, sometimes called the obsolescence period, generally 7 years from the date of first major delinquency. And then there's just the time period to call you, to write you. Generally, there's no time limit on that, but they have to be very, very careful And a lot of times they break the law. So it sounds like maybe Jefferson Capital has written to you and saying they're not going to sue you and they're not going to report it, but they're still collecting it. If it was me and I'm dealing with some debt buyer that says, I'm not going to sue you, not going to credit report, I would just send them a refuse to pay letter. Say, I refuse to pay any debt that you claim to have on me. Thank you very much. And, give them your information, your address, date of birth, last four social, so they can identify all the debts. And then if they contact you after that, usually you have a good lawsuit in that. See, Rick says, what do you think about the Biden administration abolishing the CRAs, letting the CFPB take over the credit system? So, he's floated that. I don't think it'll happen. I think the credit bureaus have too much power. There's just too much built into the whole system. I mean, you've got the scoring model through FICO, and they dominate the scoring model business. You have companies, take a Bank of America, for example, untold millions of dollars that have been spent to set up their system to interact with FICO. And I don't think they'll let the government just take all that away. And as far as whether it would be good, my concern is now we got the government handling this, which I don't have the greatest confidence level in the government. And I would be concerned about would there be immunity in essence? Like, well, since we now control this, you can't sue us if we get it wrong. Well, then what do you do? At least with the bureaus, if they get it wrong, buddy, we can take them to court and we can get money out of them. And, I'm a big fan of capitalism. I like the idea of, when it starts becoming so expensive to the credit bureaus, to the credit card companies, debt collectors, when they violate the law, they'll go, you know what? Maybe we should do the right thing. Not because we're good guys, but it'll be cheaper. So I like the idea of lawsuit after lawsuit and settlement after settlement, changing, as a friend of mine used to say, change the calculus of this, change the equation here where they go, it's more expensive to break the law than to follow it. And that's where I think we get real help. So I'm not a fan of the idea of, letting the federal government run the credit bureaus. Do you ever have to appeal cases? So it's very rare that we file an appeal. I'm trying to think. A couple years ago, I appealed a foreclosure related case in state court, and it settled on appeal. I had a company, we sued a debt collector. They tried to compel arbitration. We beat them on that. And in federal court, they have an automatic right to appeal. They did. That settled on appeal. A couple other cases in the 11th Circuit, which is over Alabama, Georgia, Florida. It's the federal appellate court. We've appealed. I want to say all those have settled also. So, in the last 15 years, we probably have filed 4 or 5 appeals. I mean, so very, very rare for us. There's an old saying that's true. You don't want to be the loser going to the appellate court. You want to be the winner, so we try to win our cases at the trial court, then let the other side consider the cost of appeal. If I'm appealing, that's something has gone wrong. And so we occasionally have to do it, but try not to do it very much. Let's see. Evelyn says it's the same when the state sells your tax debt to a third party, their attorneys. Oh, I see. So talking about, is this the same as like a Midland Funding claiming to buy a Synchrony bank account? Typically, it's not, because that tax debt, the government owns that. There's a process in your state code that says how can they sell tax debt, and there's a whole set of rules for that and a lot of violations. But that's going to be totally different than like a Midland Funding or a portfolio recovery. So you definitely want to find somebody that is knowledgeable about tax liens in your state. And if you happen to be in Alabama, reach out to me. I know the lady that, to my knowledge, she is the most knowledgeable of anybody in the world on Alabama tax liens. Let's see. Tioka Ingram says, court documents have my father-in-law's name with my name on bankruptcy. credit reporting agencies reporting my name and my spouse, but state it's verified as accurate. How can I have it removed? So let's see here. So when you say court documents, I assume you mean bankruptcy. They have your father-in-law's name with your name. So here's my question. Who filed bankruptcy? Did your spouse file bankruptcy? And then did you file? And did your father-in-law file it? I'm going to assume it's you and your spouse, but your father-in-law's name is on there instead of your name. They sort of mixed up your name. So, or maybe I have it backwards here, but anyway, just let me know, who filed and sort of the lay of the land here. Because you say the credit bureaus are reporting your name and your spouse's name, and they're stating that's accurate. If it was really just your father-in-law and your spouse and not you, then yeah, that should not be reporting it with your name. The only time it gets a little confusing is if you have a joint account. So let's say that I'm married, and to use a different example. Let's say that Tioka, you and I have a joint credit card, and I file bankruptcy. It sometimes will appear on your report as this is included in bankruptcy, even though you haven't filed bankruptcy. And there's some strategies to deal with that. But just give me a little bit more detail. I'll be glad to help you any way I can. Let's see. Miro says, got a letter. They can't sue because of age and they won't report. Yeah, so that's a good thing. That these companies are having to be more careful, because they used to would sort of threaten to credit report or threaten to sue when they knew they couldn't. And that's a violation of the law. So when you get that, definitely hold on to that letter where it says, a lot of times they'll say something like this: the law limits the period of time to sue you, and due to the age of this account, fill in the blank, Midland, Calvary, Jefferson Capital will not sue you. And a lot of times they'll say, and we will not credit report. So you just hold on to that, and they have no leverage over you. I'd send them a refuse to pay letter, and that should make them go away. If they call you, if they write you, with very few exceptions, you can sue them. This is under section 1692CC of the Fair Debt Collection Practices Act. See, Corey says, great information, watching content for months. Well, hey, I appreciate it, Corey. Thank you for watching. And Fabian says, thanks for your response. So more like a round 2 dispute if verified. Yeah, and you can, let me go back up and see if I can find the earlier comment. Okay, I think you were saying purchase agreements and contracts if we're dealing with the collector. So yeah, I would, let me tell you what somebody did, okay? And I would not advise this. They sent a letter to, say, LVMV, say, give me your purchase agreement. LVMV is not going to do that. They didn't do it. So then they disputed to the credit bureau, said, hey, we asked for the purchase agreement. We didn't get it. You can't verify this account. Delete it. It was not deleted. So they sued the bureaus. To my knowledge, they did not sue the debt buyer. Frankly, I don't think they should have sued anybody. But if you're going to sue somebody, you should have sued the debt buyer, not the credit bureaus. And that was lost in the appellate court, whether right or wrong. The appellate court, agreed and threw that case out. So, you can do some disputes and make some requests, but my focus would be on finding an error in the documents or on the credit reporting. So like if you dispute it to, let's say, LVNV, and they update your report, don't mark it as disputed, well, then sue them. That's section 1692E8 of the Fair Debt Collection Practices Act. And if they've done all that right, you may send them a refuse to pay letter, and then they may send you a bunch of documents, and then you sue them under section 1692CC. So I would look at, just really digging into details and see if you can find some errors there. Let's see. Log Home asks about how long before these junk debt buyers actually sue someone. It can be pretty quick. I've seen them hold it for years, and I've seen them buy a debt, at least they claim to buy it, and they sue in 60 days, 90 days. We're seeing more sort of fresh debt. So like maybe my date of last payment used to be 3 years ago, and then I would get sued. Well, maybe now it's a year. Okay. So, I stopped paying last year and now I'm being sued by a debt buyer. So at least in Alabama, they're suing quicker than they used to. What recourse do I have if I ask the Bureau for method of verification and they continue to reopen a new dispute? So I think what you're asking is you did dispute, they verified it. And so then you said, hey, under the Fair Credit Reporting Act, I have the right to know the method of verification. And instead of sending that to you, it sounds like they're just doing a new dispute. I'll tell you this, I'm not sure I've ever sued just for that. I think I've sued for that, but combined with other things. So I just don't have experience suing solely for that basis. I would say, the best thing is if you can find an error, obviously, then you sue for that, and you can sue for failure to give you the method of verification. They'll claim, well, we did give that to you in the results of investigation, but that's not really what the statute's talking about. So I would just kind of go back, see, is there any errors that you can point out, any incomplete, any inaccurate information, do a dispute, it gets verified, ask for the method of verification, and say in there, look, guys, I'm serious when I say I just want the method of verification. Don't reopen a new dispute. Don't ignore this letter. Give me the actual method of verification. And if they don't, then I think that puts you in a stronger position to sue. Let's see, trying to get my wife to move back to Alabama. No luck yet. She's a California girl. Well, so ironically, I was born in California. Now, I'm in Alabama. So, sometimes people do move. And, if you have some issues out there in California, let me know. I know some good lawyers in California. Be glad to help you. Let's see, Low Country. Thank you for your answer. From what I heard, CFPB will cover all mortgages, not just government backed, which would be big, help many people. Yeah, I would like to follow up on that. I did see a reference to that recently, and I'll just tell you this: I've been sort of buried in some federal cases, so just sort of coming up for air here, and so I'm a little behind on keeping up with the news. But if that's all mortgages, that's really, really big. Okay. And now that will be challenged in court, I'm sure, kind of like the eviction moratorium by the CDC. But yeah, I'll definitely check that out. So thank you for telling me about that. Let's see. LVMV filed a suit on me and the courts terminated the suit. So Antonio, let me know what you mean by that. Did they dismiss it with prejudice or without prejudice? And what was the reason for terminating it? In most states, you're going to be told this is with prejudice or without prejudice. And, prejudice in this context is sort of like in a spy movie where they say, terminate that target with extreme prejudice. It just means it's done, it's over, it's finished. And so you want it with prejudice if possible. Without prejudice means they can file the suit again. If it's with prejudice, then I would certainly look at my credit report and see, is that company that sued me, whether it's Capital One, whether it's Midland, LVNV, are they still reporting? Have they updated after that case was terminated? If it was with prejudice. And so I'd be curious to know more about that. Let's see. David says, I sent Experian a letter to remove old addresses I'm no longer affiliated with. They refused to do it because it's associated with accounts on my credit reports. How can I get the old addresses removed? Okay, so this is a frustrating thing. And to my knowledge, Experian's the only one that really plays this game. So they will say, we received your dispute, but we're unable to remove this address because it's associated with one or more accounts. If you'll reach out to the creditor and you can work with them, and then you're welcome to come back to us. They usually don't even tell you who the creditor is. Well, my view is the Fair Credit Reporting Act says I have the right to dispute any information. And if it is inaccurate or incomplete, it's to be removed. I know where I live. Here's my driver's license. Here's a utility bill. This is where I live. I don't live at that place you had me, 10 years ago. And if they won't fix it and they give me this garbage about, you can go like a needle through a haystack, and maybe you can find the creditor and talk to the creditor. I don't think so. That's not what the FCRA says. It says you, Experian, do the investigation, and you're the only one that's reporting my personal information. And so I would maybe do another dispute, just really spell it out in detail. I don't live at this old address. I want you to delete it. You told me to talk to a creditor. You didn't even tell me which creditor. So I'm asking you, which creditor? I would almost guarantee you're not going to get a personalized response. You're going to get the same form thing, or they're going to say, we deem this to be frivolous. We've already addressed this. And then I think you've got a really interesting case there to bring. Now, I like to sue for addresses when I have something else. So I have inaccurate, incomplete information on an account. So it's not just the addresses, but not saying you can't do that. It's just better if you can sort of pair something with it. But definitely reach out to me, David. Let me know what you're dealing with. You can get to me through alabamaconsumer.com, and I'd like to see exactly what they wrote you, and if you do a follow-up dispute, what they do. Mira says, yes, love your videos. I'm not sued, but your videos are welcome. Well, thank you very much. And I appreciate that. And, having that letter from the debt buyer is very, very valuable when they say, we won't sue, we won't credit report. So that's great. Let's see here. Can we remove a paid collection from our account? So if it's paid and they did not agree to delete it, then you really would have to find an error with it. Paying it doesn't mean you can't dispute it, okay? But you would have to find some error with it. It's challenging. I'll just say that. And some companies like Portfolio Recovery, unless they've changed recently, they say on their website, hey, we'll delete any paid account within 30 days. Midland Credit is a little more obscure. It depends on how far from the date of first delinquency. So there's definitely a trend toward removing the paid collection, but the bureaus hate that. And the collectors that won't do that, they hate that other collectors will delete. But just look and see if there's some type of error there that you can dispute. Let's see. Eric says, original creditor in court, what's the difference in settling by calling the creditor's lawyer directly or hiring my own lawyer? Settle it. Will settlement amount difference be significant? Yeah, it's a great question. So let's use an example. So say that you're sued for $10,000 by Capital One, and you could settle it on your own for $7,500, or you could pay a lawyer $2,000 to settle it for $5,000. Well, you come out a little cheaper using the lawyer. You do have to factor in tax consequences of debt forgiveness. Okay. The reason that you typically would hire a lawyer is either you don't want to mess with it. Okay. You're like, I don't want to talk to this lawyer, this, collection lawyer. I don't want to have to worry about getting my answer in, not getting a default judgment. But the other reason is because you believe that you can settle it in total for cheaper than doing it on your own. Unfortunately, there's no way to know for certain. We kind of need, identical twins with the identical account, and one does it on his own and the other hires a lawyer. And, that's kind of how we would do in randomized control, blind study, right? Is we sort of test this out. Well, you can't do it here. Generally, I can tell people, look, this is what I can settle this for. Do you have any settlement offers from the lawyer after the suit was filed? Then we can kind of compare it. And generally, I know what people can settle for. And I also ask people when they settle it on their own, come back to me and tell me. So, okay, on that $10,000 Citibank account, what did you get on your own? Because that helps me to know, okay, here's what I can get, and here's what my fee is, and here's what the client will pay. Does it make sense? And sometimes I tell people, look, it doesn't make sense to hire me. And, you should do this on your own. Here's the lawyer to call, kind of get around the collection pit there and just go directly to the lawyer. So, Eric, I would get with the lawyer in your state that does this type of work and just ask them. And, if you get a good feeling that they're being honest with you, then, you can then I would, trust their advice. So Rena says, hello, John. Well, hey, good to see you again. Can you recommend a good law firm lawyer in California, Newport Beach? Yeah, so get with me. Just reach out to me through alabamaconsumer.com and let me know exactly what type of lawyer. And I've got somebody in mind that I think will work, but it does depend on exactly what type of case you have. And let's see, Evelyn says, sad our judicial system corrupted, controlled by the banking system. Yeah, look, there are certainly very powerful people that have a tremendous amount of control in our society, and no question about that. Yeah, so again, modern banking system. I'll say this: the concept of our consumer protection laws, like truth in lending. Truth in lending doesn't really forbid anything. It just says you got to disclose. You got to be honest with people. Then we have other laws that do say like this is excessive. And, I'm more of a person that if I go take out a loan and I can't pay it back, but I knew what I was doing, I got to pay the consequence for that. Maybe I have to deal with collectors. Maybe I have to deal with lawsuits or file bankruptcy or whatever. So I'm more of the category of, make sure people are not lied to. Now, when companies lie, like Wells Fargo did all that bad stuff, opening bogus accounts and, just terrible things. And so I definitely sue these banks. My hope is that they would be very transparent, very honest with here's what we're doing, and then people can make good decisions. But I'm more on the side of people can make their own decision. If it's a high interest rate, if you choose to do that, you do it. Sometimes you don't have a good choice, and but I definitely think that there are very unethical practices. And what we do, just sort of full disclosure, when we sue these banks, we sue these credit bureaus, we're looking for how do we present this in a way that the jury comes to the conclusion this is not a one-off event. That's always what defense lawyers say. Oh, this is just a one-off. We just made, never happened before. It's just a single mistake. And we say, no. This is systemic. This is how you do business. My law partner likes to say, McDonald's doesn't flip one hamburger at a time. They flip 10,000 hamburgers at a time. In other words, like Wells Fargo opening bogus account. That wasn't just one guy that did that in one office. Okay. That was company wide. That was encouraged. That was tolerated. That was rewarded. And so we want to show that this is a systemic problem. Okay. So a debt collector calls your mother-in-law. All right. That's a third party disclosure in almost every circumstance. And she tells your mother-in-law about the debt. Hey, we're going to hammer that debt collector, that collection agency. But we're not going to do it in a way say, oh, this was some rogue employee. No. This was the star employee, and the supervisors knew what she was doing, and they tolerated it because she brought in money and they encouraged it. And so don't tell me about this as just some rogue employee. No, this is the highest levels of management. So we're always looking to show that this is unethical and it's widespread. Okay. But just in general, do I think the banking system is, immoral or unethical? I don't think the concept is. I think sadly, a lot of the execution of how they do things, it does turn out to be that way. So Muriel says, hit the like button. Well, thank you very much. I appreciate that. And let's see. Tioka, yes, that's correct. My husband and I filed. My husband and father. Okay, I'm sorry. My husband and I have the same. Husband and father-in-law had the same name. Just received a copy of the court documents listing my name with my father-in-law's. So I would say get with your bankruptcy lawyer and get that corrected in the bankruptcy court, because it sounds like then it's well, let me ask you this. So in bankruptcy court, you and your husband filed, but it has your father-in-law's name and your name. But then on the credit reporting, is it showing up correctly just under your credit report and your husband's credit report, not your father-in-law's? My concern with it being, with it listing, as I understand it, your father-in-law's name in the bankruptcy court, it may show up on his reports. And, that's awkward. He may not have known you filed bankruptcy, and that would be, embarrassing to your husband there. So I would just try to fix that with your bankruptcy lawyer. Okay, case was dismissed and closed. We never followed through with the bankruptcy. Yeah, if you filed it, it can still be reported as a filed bankruptcy. It will just say dismissed instead of discharged. And let's see. Appreciate time helping many, in my opinion, keep up the good work. Well, thank you very much. I appreciate the encouragement. I'm going to try to wrap up these comments, and we'll close this down here. Let's see. Well, so try to reach your office past 3 days. Sent you an email. I know you're extremely busy. Thank you for all your videos. Ready to give out to. Well, I'll tell you this. I have actually been on the road for, I guess, yesterday was the first day. I wasn't on the road, and we've had a bunch of trials and things. So I am unburying myself from emails and messages. So I apologize, or just reach out again through Alabama Consumer, and we'll definitely get you a response to that. So sorry, we have not responded to you as of yet. Muriel meant to rewatch this because going, well, thank you. And if you're having insomnia, I'll definitely take care of that. So, but I appreciate the kind words. Let's see. Victoria says, when factual dispute comes back verified, sue both the servicer, so Navient, as well as FCRA. Yeah, if there's an error, an inaccuracy, incompleteness, and you specifically have spelled it out, and you send that to the bureaus, you can prove the bureaus got it, and then it comes back as verified, then we always sue the furnisher, and we normally sue the bureau, assuming that this is something the bureau could have corrected. Okay, so let me give you an example. If I say to the bureaus, I called Discover Card 3 months ago and they told me I could skip a payment and they wouldn't report me as late, and they did report me as late. Now, I would do that dispute. If it comes back verified, I probably would not sue the bureaus because they don't really know, did I have that phone call? But Discover knows, because as I'm talking to their employee, Discover knows that, okay? The knowledge is, the fancy word is imputed to Discover Bank, okay? So there are times where I say, you know what, this would not be fair to sue the bureaus because they have no way of knowing. But when it's information on the report itself, so there's missing information, or, it says I was 60 days late, and then the next month it says I was 120 days late. It's like, how can that be? Or there's, I can't remember if I used this example in a previous video, but I've got the original creditor saying that they sold the account in, I think, January. They sold it, but the debt buyer portfolio says they bought it like in November. Well, somebody's lying here. Okay. And so we can point that out to the bureaus and show, look at this information. It's contradictory. Well, now they're on the hook. Okay. Or if I give them the documentation proving the error, they're on the hook. And so I look at suing them. But just in general, yes, I'm looking to sue the bureau and the furnisher. And let's see. What's your opinion of crypto? Is a good idea keeping thing you have since it can't be garnished from collection attorneys since it's outside the system? Not trying to be crazy. Thank you. So it's a very fascinating thing with cryptocurrency, because if there's a judgment against you, you can be forced to reveal your assets, and those can be seized, assuming state law allows it. So the deal with crypto is, you own that. Like crypto, it's sort of designed to be outside the system. It's not really. Like, ask the IRS, do they think this is outside? Like, they are hammering people who, they buy some cryptocurrency for $10,000 and sell it for 100 and don't report that gain. The IRS says, hey, buddy, you owe us money on that. And so it's not really outside the system. Where it becomes interesting is when, so like somebody got a judgment against, I forget his name. He ran like a, what do you call it? Cryptocurrency exchange. Maybe I'm not using the right word, but he like stole a bunch of money. Okay. I want to say like $120 million in cryptocurrency. And, they went after it. And he's like, I forgot my password, or I gave it away to some unnamed person in Russia, and I don't know who I gave it to. Well, put aside whether he's lying or not. I mean, unless they have the password, they can't get to the cryptocurrency. So now they can potentially hold you in contempt for that. And so my point is, if you have Bitcoin or whatever it is, that's subject to being taken in a garnishment. It just is obviously more challenging than if it's sitting at, Wells Fargo Bank. So let's see here. I think I've got to the end of the comments. So yeah, this is the last one. So thank you very much, Muriel. I always appreciate you being on here. Thank you for everybody for your questions, comments. If you need anything, feel free to reach out to me through alabamaconsumer.com. We'll be back in 2 weeks, and Stephen Palmieri should be with me there. And so we'll look forward to doing this again. And I will do my best to get some videos back up on YouTube. And if you're interested in our weekly webinar, just I don't have the link here to sign up for it. I don't think I do. Yeah, I don't think I do. Just reach out to me through Alabama Consumer. Say, hey, like the link to sign up for the weekly webinar, and all that's free. We also have a daily email that goes out, and if you're interested in that, just let me know, and I'll point you in the right direction for all of that. And you guys have a great day, and we will talk to you soon. Okay, bye-bye.